what would you do if a client approaches you after the receipt of notice of arbitration and you are supposed to respond to that notice? So in this case, you will step into the shoes of a respondent's attorney. Then again, the normal procedure, go through the notice with your client, get your clients to comment on the factual areas, factual matrix, the claims made by the other side, the documents cited by the other side. Get your client's comments, then proceed to draft a reply. And the first step, which I normally advise my colleagues in my office also, is that also proceed to file caveats. Again, if Section 9 provisions are applicable as a part of your dispute, proceed to file caveats so that you get notice from the concerned court before any ad interim relief is granted against your client. Respond to the notice, deal with it on merits. Do not at this stage delve into too many details. Give a very crisp reply. And at the same time, whilst responding to your notice, if your client is agreeable, as far as your other defenses are concerned, if you are agreeable and ready to provide a name of arbitrator as a nominee arbitrator on behalf of your clients, then while issuing the notice, put down the name of the arbitrator as your nominee arbitrator. A critical aspect in this is while choosing to respond to a notice, also check on the aspect whether the dispute referred to in the arbitration notice is arbitrable in nature. It fits into the definition or the arbitration agreement, whether it is the possible dispute that is referred to in the arbitration agreement. So check on that factors as well before responding to a notice, because whatever you state in your notice, though in brief, also becomes a part and parcel of your statement of defense for your client. And ensure that the notice is dispatched well within the time frame of 30 days, and all possible objections as far as arbitrability or insufficiency of stamp duty on the arbitration agreement are taken up at this stage itself.